So I said I had some news for y'all about what was happening in court, and we haven't been covering motions as heavily in this case as we were in the YSL case because one, there really hasn't been that much movement. And two, sometimes it just gets a little boring. This one is interesting though, because it seems like there's been some drama inside the court. And shout out to Lena Del Turtle in the building for posting this. It looks like she says that Karen Reed's defense team is asking Judge Beverly Cannoni to prevent the McAlberts from staring down the jurors. Oh my gosh. Things are getting petty in here. So let's look at this motion in limine and see what's going on. We've got a motion in limine here. The Commonwealth versus Karen Reed. The defendant's motion to exclude certain witnesses before and after testimony. What is going on? Now comes defendant Karen Reed and respectfully moves this honorable court in limine to exclude certain witnesses from the courtroom before and after their testimony at trial in this matter. Now, I pointed out Peggy was one of the people who was in the courtroom before her testimony. She testified and now she's sitting in there after. Honestly, this seems like something that would be standard. And we talked about this when it came to certain people like Denise testifying. A lot of you said, oh, she's not going to testify because she's been sitting in the courtroom. That doesn't matter here. And it's really up to the judge's discretion if, in this case, she wants to allow certain people to testify, even if they've been in the courtroom, right? Rule 21 of Massachusetts Rules of Criminal Procedure states that upon his motion or the motion of either party, the judge may, prior to or during the examination of a witness, order any witness or witnesses other than the defendant to be excluded from the courtroom. Makes sense. And then they cite the law there. The power of a judge to control the progress and within the limits of the adversary system, the shape of the trial is universally held to include the broad discretionary power to sequester witnesses before, during, and after their testimony. Reporters' notes to Massachusetts Criminal Procedure 21, citing, they've got Geeter, it's hard to see that. Geeter versus the United States, or G versus the United States, and H versus the United States. United States versus Robinson, and the United States versus Eastwood. The Commonwealth versus D, the Commonwealth versus Watkins, the Commonwealth versus V. They cite all these cases where the witnesses were told, hey, you can't be in here. You got to go. Miss Karen Reed specifically requests that the court exercise its broad discretion to exclude Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, so they're going to testify, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after the testimony at trial. Now, I haven't seen Jennifer McCabe in there. Her testimony's done. She's not coming back. Chris Albert looks like he's going to testify. Julie Albert's going to testify, so I'm glad we didn't read her testimony or see her testimony. Brian, Nicole, Colin. So Nikki is going to testify. We've got Matthew McCabe and Brian Higgins. Brian Higgins is coming back as well. So I'm glad we didn't watch his testimony either. After this court likely recalls, as this court likely recalls, after they testified, members of the Albert and McCabe families proceeded to sit in the gallery with the O'Keefe family facing the jury sporadically throughout the remainder of the trial, including closing arguments. Oh, interesting. So were they intimidating the jury? Following the trial, a juror reported to Vanity Fair magazine that he or she felt it was utterly inappropriate that the Alberts and McCabe families were able to stare down the jury from their position in the courtroom gallery. Oh no. Hey y'all, we see how Paul is over there looking. He's all sitting down like this, making those faces. I can understand how the jury would feel intimidated. And it does seem inappropriate. And I don't know why they're in there in the first place, to be honest. One juror reported to Vanity Fair magazine that he or she felt intimidated by the presence of the Albert and McCabe families, calling their presence in the courtroom's small gallery facing the jury completely and utterly inappropriate. Noting that the Albert and McCabe families were substantial focal points of this trial and still are, the juror noted how unbelievable it was that the families were allowed in to stare down the jury. Wow. Julie Miller said, Karen Reed tells her story part 2 in Vanity Fair of October. Some of this is redacted. I don't know why. This was extraordinarily prejudicial to Miss Reed. The alleged third-party culprits, Brian Albert, Colin Albert, and Jennifer McCabe, all sat in the gallery during closing arguments, directly facing the jury, which, according to at least one juror, was intimidating. See Casino, and then they quote another source. It says purportedly that an act need not be overly threatening to be considered intimidating. That's true. They also say defining the threshold of intimidation as what would instill fear in a reasonable person. Because imagine if the defense is able to prove that there was some crazy stuff going on here and there's a cover up from a murder. And you're seeing the people who were allegedly involved. You've got the Alberts. You've got Jennifer McCabe, who was there when it happened, sitting there across from you, staring at you. Like, what's your name? Oh, Jim. Jim what? You from around here, Jim? You might want to move cities. Hey, listen, stay away from me, man. Y'all got some ish going on. I don't know what's happening. You got a weird relation. Jennifer McCabe has a weird relationship with John. Stay away from me. So just their presence alone, I can understand how that would feel weird. As the jurors heard through testimony, the Albert and McCabe families have deep connections and familial ties to multiple state police forces and local government. In addition, Mr. O'Keefe, a Boston Police Department officer, was a part of this tight-knit law enforcement community. By sitting with the family of John O'Keefe and continuing to face the jury for parts of the remainder of the trial, at least one juror felt intimidated by what he or she perceived as the Alberts staring the jury down. Here, the judge has broad discretion to order the sequestration, I got that the first time, of witnesses before or after their testimony at trial. A defendant has a constitutional right to a fair trial to be decided by an impartial jury, free from intimidation and undue influence. Given that at least one juror reported feeling intimidated by the presence of certain witnesses toward the end of the trial, Ms. Reed respectfully requests that the court exercise its broad discretion to issue a sequestration order excluding Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after their witness testimony to prevent further prejudice to Ms. Reed. Conclusion. For the above reasons, Ms. Reed respectfully requests that this honorable court exercise its broad discretion to exclude Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after their testimony at trial. Respectfully submitted, Karen Reed, represented by Alan Jackson. What do y'all think about this? I can totally see what they're saying. And honestly, I don't understand why they should have to ask for this. I mean, you have the grieving mother sitting there during trial, hearing this testimony, and the jury's looking at her over there, tearing up, and she's testifying. Get her out of there. That doesn't seem fair in any way, shape, or form. And then you've got, again, these people who, according to the defense, were trying to cover up things. They went to great lengths to make sure certain information wasn't found. Jennifer McCabe seemingly had an inside job done when it comes to what was able to be accessed on her phone. And then we still haven't even heard the testimony from some of the others. We see Brian Higgins going to the police department on video, on the phone, saying he couldn't access his phone. We see clearly he was on the phone. I would not to be around any of these people. I wouldn't want them to know who I am. And seeing that they have this type of power and access, I'm just here to do my job, guys. I don't know how much they get paid on the jury, but it's not worth all this. I could see Judge Cannone granting this motion, and I think it was a smart move by Alan Jackson as well. Let me know what y'all think about this in the comments and in the chat.